Real Estate Appraiser Commission to order. First order of business, would you call roll?
Yes. Michelle Alexander. Here. Dr. Warren McCara.
Here.
Jason Bennett.
Here.
Jim Atwood.
Here.
Randall Thomas.
Here.
Rex Garrison. Here. And Brett Mansfield.
Here.
We have quorum.
We do have a quorum. All right. Our first order of business in the January meeting is to elect a chair. So before we get on the phone with the gentleman, we'll open the floor for nominations for a chair.
I'd like to nominate Mr. Randall Thomas.
Second.
I'd like to nominate Rex Garrison.
Second.
Any others? Motion been made to nominate Randall Thomas as chair. Motion's been made to nominate Rex Garrison as chair, and both have been second. Do we have to do this verbally?
I don't know the answer. I think so.
I would say yes, or because of the Open Meetings Act, we want to make sure that everything that we do is open to the public. So.
Okay. Is it okay with you if we take these in order? Just okay. Vote on the nomination for Randall Thomas for chair. You want to call a roll?
Okay. Michelle Alexander. Yeah. Dr. McCara.
Yes.
Jason Bennett.
Yes.
Jim Atwood.
Yes.
Randall Thomas.
Yes.
Rex Garrison. And Brett Mansfield.
Yes.
The motion passes.
Okay. No, I'm a little confused here. So do we want to go ahead and there's no need?
No, I think we have.
Okay.
Yeah.
Okay. All right. Motion carries. Randall Thomas will be the chair for next year. All right. Thank you very much. Appreciate you putting your confidence in me. Maybe Jennifer, you could give us a little background on our caller.
Actually, Anna Matlock is going to do that.
Okay, I'm sorry. Can you tell us where we'd find it here, Anna?
Yes, hold on 1 second.
We actually need to adopt the agenda first.
Right.
Okay. Okay, you've all had to see the agenda. Make a motion to adopt the agenda.
So moved.
Second.
Motion been made and second to adopt the agenda. Anybody have any questions? All those in favor say aye.
Aye.
Any opposed? Agenda is adopted. Okay.
Thank you.
All right, Anna.
So before you, we have an applicant that is appearing before the commission due to prior disciplinary history. So we have Mr. Pullum. Is that correct?
Yes.
Mr. Pullum, go to your iPads. It is item number 2. And if you'll begin, you'll see the application summary. And then the National Registry report begins on page 5. And then we have a series of documents that begin on your iPad on page 8. So for the first document we have here is a consent settlement order from...
Sorry to interrupt.
Sorry.
Mine's not set up in the page format. Is there like a sub or a main folder or what's?
Just tap on it and hit library in the top left corner.
Oh, is it under the legal report? Is that?
It's under the second one under his name. Do you see?
It's at the bottom.
No, this is. Oh, it is, but you.
Okay.
So the consent order begins on page 8 of this document. If you'll scroll through the consent agenda, it is essentially what has happened is Mr. Pullum was found responsible of several use PAP violations. The use PAP violations begin on page 8 and end on page 16. And then if you'll go to the bottom, if you'll go to page 17 of the document, you'll see where the licensee agrees to pay an administrative fine of $4,500 to the board within 30 days, and that represents a $450 fine for each of the 10 use PAP violations. And then the licensee also shall complete a board-approved 15-hour use PAP course, and that is the extent of the first signed consent order. You'll see that it is signed by Mr. Pullum, the licensee, and also signed by the executive director for the Alabama Real Estate Appraisers Board. Next, we have a final order that begins on page 20 of the document. This is a final order which is following a formal hearing, I guess our equivalent of a formal hearing on another use PAP, on another appraiser matter. If you wanted to quickly review, it reviews the evidence that was presented at the hearing. Oh, hold on. Sorry. It shut down on me. But we're more concerned with if you wanted to review the various violations, what took place during the hearing. Okay, findings of fact and conclusions of law can be found on page 27. So what you'll see in 1A, B, C, and D are the various use PAP violations. And based on those findings of fact and conclusions of law, we're on page 28 of the iPads. You can see that the an imposition was made by the of 6 months suspension and administrative fine of $1,200, and this was done on the 30th of November 2011. The last we have is another order that begins on page 30. This is also before the Alabama Real Estate Appraiser Board. It is an order, and you'll see here on page 31 what the judge has ordered. Essentially what it is a 6-month suspension and 15-hour use PAP course. And that the respondent is required to attend appropriate training with respect to safeguarding his electronic signature and submit proof of completion. So that's the order. Following that, if you wanted to look on page 33 through 47, are the findings of fact, conclusions of law, and recommendation. So these are the orders that we have from the Alabama Real Estate Appraiser Board. Essentially, before you. The reason we have this here is because if someone has prior discipline in another state, they're required to come before the commission for approval for their license. You'll notice that the National Registry there aren't any particular findings. It's because these are older than what is required to be considered in good standing. So technically, Mr. Pullum is considered to be in good standing with the National Registry. If Mr. Pullum, if you would like to tell us anything about what we've had here, or Chairman Thomas, did you want to?
Yes.
Yes.
Mr. Pullum,
Yes, sir.
this is Randall Thomas, Chair.
Yes, sir.
I'll give you 10 minutes to tell us anything you want us to know. And then I assume you're prepared to speak to us, so I'm going to assume you're prepared to answer questions from any or all of the commission members. Is that correct?
Yes, sir. That's
Okay.
correct.
All right, go ahead.
Okay, originally, back when all this first started, I was a mentor for several appraisers or trainees, and basically got myself in trouble with USPAP. And I did the courses to rectify all of this, and up until the very last disciplinary action, I had an employee in my office that stole like $100,000 worth of appraisals, and I had no idea of it. And make a long story short, the board expected me to prosecute this employee, and I didn't. So I agreed to just allow my license to be suspended for 6 months because my wife was sick and I was taking a little break anyway. Now, it's been several years since I've had any kind of disciplinary action, and I've been doing appraisals for about 30 years. And I would like to say all of this happened because other people, I was helping them, but it's all my responsibility. Everything you see on my record is my responsibility. But I haven't had any action or any problems in the last 10 years. And I live on the line of Alabama and Tennessee, and I do get requests. And I had Tennessee license for probably 15 years and never had a complaint. So I would appreciate if I could reciprocate with Tennessee to get a few appraisals in the Tennessee area, since I do live bordering on the line. And I'm open to any questions that anyone has. I think that's basically it. And you can see my record. I'm not really proud of the things that have happened, but I did take the USPAP courses. I did pass the USPAP courses. I have been in appraisal business for over right at 30 years. And I just would appreciate your consideration for me to reciprocate with Tennessee. And if you have any questions, I'm all open.
All right. All right, thank you, sir. Does any commissioner have a question? I have just one question, maybe of you or Anna. You read twice that there was a 6-month suspension and then it's another 6 month. Is that a total of 2 6-month suspensions, or is that just one?
It's my understanding, based on the order, that there were 2 separate 6-month suspensions.
Mr. Pullman, can you clarify that for us?
Yes, sir. The first one was, like I said, I was mentoring other appraisers, and I had signed in appraisals with them, and the violation was for USPAP. And I agreed to take a 6-month suspension versus fighting it. And that's just basically it. And the second one was, like I said, because of I would not prosecute the lady that stole my identity. And the board, the judge said that I needed to secure my office better and watch my employees better. And that I have done since then. And, of course, my son was an appraiser, and my son-in-law is an appraiser. And these are people that I had mentored over the years that have not been in trouble. But to make a long story short, I just didn't really need the license at that time due to my wife being bedridden. And I was basically, and still am, taking care of her to a certain extent.
Alrighty.
I have a question. Sir, am I on now? I don't know.
Yes, sir.
Can you hear me, sir?
Yes, sir.
Your statement was that someone stole $100,000 worth of your reports, and then you just made a statement that it was stolen identity. Could you explain that just a little bit more for me to understand?
Yes, when I went before the board, I didn't have an attorney. When I went before the board, uh, she had been doing appraisals in the Birmingham area of Alabama, and I had no idea she was doing them. Her and the mortgage company had were doing appraisals, and I had no idea till they was turned into the board. And that's the reason the judge, she even spelled my name wrong when she was signing my reports, and that was on 4 different reports in the Shoals area. And when I got before the board, the judge recognized it, and he said, "How you spell your name, Mr. Fulham?" And I told him, he said, "These can't be your reports because I think you could spell your name right." And I said, "Well, I think so." And we looked at them, and they didn't charge me with violation of USAP on those. But like I said, my wife was at a point where I had to help take care of her, and I agreed for a 6-month suspension.
Did the Alabama board bring charges against her, and did the state of Alabama bring charges against her?
No, sir, they did not. They left that up to me, and that was my question also. I felt like it was their obligation to bring charges, and she was a realtor, which I'm a Alabama realtor myself, but she was a realtor and an appraiser, but she was using my name to get business from a certain mortgage company that is no longer in business.
Your official signature did not appear on any of those reports.
No, sir.
Not an electronic signature that you gave her permission to use.
No, sir. Not a one of them.
Yep. Just a follow-up question to that. I'm Commissioner Atwood, having a tough time connecting the dots. So she stole your signature, or was putting appraisal reports in your name, got turned in, and she didn't get in trouble, and you got suspended for 6 months.
Yes, sir. That's exactly right.
Alrighty. Anyone else have a question?
I do. This is Fred McCara. Is she still a real estate appraiser?
She's a realtor. She works for a big real estate company, and that's all she does now.
She had no consequences for what she did, legally or otherwise.
None whatsoever.
Thank you.
And she was an appraiser, though?
Yes, sir. She was. As far as I know, she was. She was a realtor. Yes, she was an appraiser.
Alrighty. Rex, you got something?
Was she a licensed?
I'm not really sure. All I know is she came to my office several times when I wasn't there, and she had been doing appraisals for this particular mortgage company. And since I had been mentoring different appraisers over the years, she just took it on herself to sign my appraisals and to get business. And I never got the money. I never got any benefit out of it. And she didn't work in my office. She was working out of Huntsville and Birmingham. Her name was Terry Madison. To make a long story short, that's her name. And she is still a realtor with a company and just sells houses now. And her name was written in the log or in the disciplinary action that she had stole. And the investigator, he and I went out in the office, out in the hall, and he said, "Mr. Fulham, why don't you prosecute her?" And I said, I'm not. I feel like it's your job and it's the board's job, and if they're going to prosecute somebody. He said, "Well, we don't do that because she's not a certified appraiser. Because she had been, she'd have been using her name, and she never used her name at all."
Were Were these 4 appraisals that you speak of, was the property in the state of Tennessee?
No, sir. Nothing's ever been in the state of Tennessee. It's Alabama.
Okay.
No, I worked for banks in the state of Tennessee when I was licensed, but I was also certified in Alabama, and I held license in Tennessee for, like I said, probably over 15 years, and never had a disciplinary action whatsoever.
Are you certified residential or certified general?
Residential.
And your work is all residential?
All residential, yes, sir.
And how long have you had your license in Alabama restated?
10 years, I think.
With no complaints?
None whatsoever. FHA and, I've been on the FHA list and everything else with no complaints whatsoever.
And you're currently in good standing in the state of Alabama?
Yes, sir.
Anyone else?
And I would like to just say this. When I spoke with the board to get to reciprocate for Tennessee, one of the executive members of the board said, Mr. Fulham, this will follow you, but she said, I don't know why it would have an effect on you reciprocating, because you only have to keep appraisals for 7 years, and you've done your time, you paid your dues, and I'm behind you. We're behind you 100%. So I'll just throw that in for good measure.
Okay, now, just so I understand what we're doing, what exactly are you asking us to do? Just to give you a Go ahead, sir.
A reciprocal license, yes, sir.
Okay. Anna, do we need to vote on this now?
Yes.
Okay. Anyone else have any questions?
Mr. Fulham, I have one question for you. You stated that the lady in question who stole your identity was an appraiser and was not an appraiser.
Well, I thought she was an appraiser, okay? She told me she was an appraiser. But come to find out, she was only a real estate agent trying to get her license. The best of my knowledge, that's what happened.
Okay, so you were never her sponsor. She never worked for you directly or your real estate firm?
No, sir. Never.
I've got one other question. When was the last time that you completed an appraisal in Tennessee?
Well, when I had license, I let my license go up there, I don't know, I would say 4 or 5 years ago.
Just for the record, you do claim that you have competency to work within the state of Tennessee.
Oh, yes, sir. I'm borderline. I'm North Alabama. I border Tennessee.
Any further discussion? Any more questions? Commissioners ready to vote?
We got to make a motion, don't we? I'll make a motion. Make the motion that we accept his application in the state of Tennessee. He's had 10 years of clean service. He sounds like someone who needs to be given a chance and opportunity. So I make the motion that we accept his application.
A second.
Motion's been made and seconded to accept his application for reciprocation. Any further discussion? Ready to vote? Let's do a roll call.
Michelle Alexander.
Yes.
Dr. McCara.
Yes.
Jason Bennett.
Abstain.
Jim Atwood.
Yes.
Randall Thomas.
No.
Rex Garrison.
Yes.
Brett Mansfield.
Yes.
Passes.
Motion carries. All right, Mr. Fulham, you'll have to get back in touch with perhaps Mr. Best or the commission here, and they'll lead you from that point on. Thank you for your time.
Thank you for accepting it. Thank you.
Thank you, sir.
Good luck to you.
Good luck.
All right, bye. Am I ready to hang up now?
Yes.
Okay, thank you.
All right, next on the agenda is to review and approve the minutes from the October 21st, 2019 meeting. Minutes were sent to you. Anyone have any questions or additions or improvements to it? Entertain a motion to accept the minutes.
I'll make a motion.
Motion been made and seconded. Any further discussion? All those in favor say aye.
Aye.
Any opposed? All right, we accept the minutes from October 2019. Experience reports. That's you.
Just 1 second, let me pull it up. I have a different set of
Okay.
documents. The next one I have is the education reports on mine.
We
Am I
got
missing one?
experience in front of education on our agenda.
Okay.
That's typical.
Did we have any interviews?
Yes.
Okay. Will, do you want to do those?
Yes.
Dylan Harper
Yes.
and Molly Burke.
We're gonna yes based on she's gonna send me a couple more things within the next week. So
Next,
Yes.
next I have Mr. Randy Thomas,
Yes.
and then finally had Mr.
Yes.
And then Mr. Spencer.
Yes. I think on the one I have has Lance McElroy. I think that may have been last meeting.
Okay, all right, that's all we had for the experience interview.
Okay, all the experience interviews are in. Anybody have any questions? Entertain a motion to accept.
So moved.
Second.
Motion been made and second to accept the experience interviews. Any further discussion? All those in favor say aye.
Aye.
Any opposed? Motion carries. Thank you. Education report. Dr. McCura?
Yes, we had 8 course applications. All were continuing education, and all were traditional classroom, and I recommend approval of all 8. I should mention that one of the courses, course 2364, one of the course instructors, Mike Orman, was disciplined. In fact, he was disciplined by this body in January 1995. But I don't deem that that should prevent him or prevent this course from being approved. So I recommend acceptance of all 8 courses in the course applications. There were 2 individual course approval applications, and again, I recommend approval of both of those. Finally, there were 2 instructor approval applications, and I recommend approval of those 2 course applications. So the Education Committee is recommending the approval of 8 course applications, 2 individual course approval applications, and 2 instructor approval applications.
All right. Motion comes from the committee, so it doesn't need a second. Anybody have any further discussion on the approving? All those in favor of approval, please say yes.
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 Any opposed? Motion carries. Thank you, Dr. McCura. Legal.
Okay, we have the legal report before you. First, I just wanted to take the time to introduce you to Miss Kristen Downey. If you'll remember, Miss Downey prepared the October legal report, but she wasn't able to be here. So she's going to be working as a disciplinary counsel for your programs. She's been with the department since September of 2019, and I think you're in really great hands. I'll still be your attorney, but she's going to be handling the complaints. So I will turn it over to her.
All right, Kristen, let me just say this to you. Welcome. I hope we don't scare you. More importantly, I hope you don't scare us.
I'm sure I won't.
We just want you to, I don't know if Jennifer's had a chance to go over. Okay, good. Yes, just do that briefly instead of reading every single word. Go ahead. I'm sorry.
No problem. Number 1, 2019-05-4441. The complainant alleges that respondent never informed them of the respondent's arrival and did not ask permission to take pictures of their home. The respondent filed a response stating that they don't have a work file on that property and they've never had an assignment but just saw the for sale by owner sign on their property and wanted to obtain some basic details in the event that they engage in future appraisals for a similar property. It didn't seem that there were any allegations of use PAP violations, so I recommended dismissal on this one.
All right. You've all heard attorney's recommendation to dismiss number 1. Is there any discussion? Entertain a motion to dismiss.
Can you wait just a moment? I am not on the right page.
Okay. Hang on.
What page is it on?
On page 1.
Brentwood.
I'm ready.
Okay. Entertain a motion to dismiss.
So moved.
Second.
Our motion been made and seconded to dismiss. Any discussion? All those in favor say aye.
Aye.
Any opposed? Thank you. Number 2.
Number 2 is 2019-07-6281. The complainant alleges that the respondent provided an inaccurate appraisal of their home, and the comparables used for their appraisal were not appropriate. The respondent stated that the sales used all the sales used were in the subject development according to the records obtained in the MLS selling agent. Complainant's real estate licensee submitted 5 sales, but only 3 were in the subject subdivision. Respondent reviewed the sales and could not justify the increase. The reviewer conclusions indicate that overall the report has been conveyed in an appropriate manner, providing sufficient information to enable the clients and or intended users to understand the rationale for the opinions and conclusions provided. The report indicates that the appraiser understands the appraisal process. Recommendation is to dismiss.
All right, you've heard counsel's recommendation to dismiss. Do I entertain a motion to dismiss?
Well, I have a comment
Okay.
before the motion. The first sentence says the reviewer's conclusions, sales comparison adjustments are not supported, but then goes on to say that the report's great. Well, the report is not great if they didn't support their adjustments. Yeah.
I guess the reviewer's point was that it didn't really affect the overall value.
I'm glad you didn't say it didn't matter.
No, I'm not going to make that mistake and say something like that. I do think it matters, but overall, it didn't really affect the outcome of the report. So I guess that's why the reviewer came to that conclusion, and because of that, I don't think discipline would be appropriate in this scenario, but I'm welcome to hear any other thoughts.
I have 2 thoughts. Number 1, supporting adjustments, not supporting adjustments can lead to a misleading report. And number 2, the reviewer that doesn't know that shouldn't be a reviewer. That's my two thoughts on this one.
So in saying that, do you wish to make an alternative motion?
Well, I'll make a motion. The individual does not have any disciplinary history, so in that case, I would just make the motion to the respondent a letter of education take a sales comparison course.
I'll second that.
So, like a recommendation or a requirement?
I'm going to make it a recommendation this time.
Okay, so like a letter of,
Unless somebody wants to bump that up, I would entertain that thought as well.
so we have letter of instruction, we also have letter of warning.
We also started something a couple of years ago where if they don't have any prior disciplinary action, that we can make a suggestion as far as continuing ed on their next cycle, that they take a certain education topic, and if they do that, then it's a non-issue.
So you all.
It's a
what you're-
conditional type.
Conditional
Yes.
dismissal.
Mhm.
Okay.
You live with that, Mr. Atwood?
Can I make a second motion to the reviewer?
No.
I can't?
Okay.
I can live with that.
What if they didn't take that class? It's dismissed based on that condition. What if they didn't take it? Then where are we
Well,
at?
the next time, if they get in trouble, they're going to have a big penalty.
So it's dismissed either way.
And this letter, I'm confused on the letters. I know we do a bunch of letters. This one does not affect.
So let me clarify a couple of things. So a conditional dismissal would be that we send them an offer to take a sales comparison approach class or whatever you decide, and then that class would count towards their continuing education. They of course have to accept this. If they don't, it's brought back to you for possible formal discipline. So letter of instruction is we are instructing you, we've found an issue, here's something that you can do in the future for correction. A letter of warning is a step above a letter of instruction. Letter of warning goes on to the National Registry, is considered discipline. We would be warning an individual that we have noticed what has happened. This is what you should do. Do not do this in the future. And then it's something that we would consider should this person be disciplined again for possible consent order or anything further. So you have 3 different options of decisions. However, the letters of warning and letters of instruction do not require acceptance from the respondent. Those are just issued unilaterally. The respondent has to agree to a conditional dismissal.
My only concern with reading this is the reviewer even correct saying that the adjustments weren't properly supported? How do we know based on the comments in here? He's saying they're not properly supported, but the report's great. Does he have any idea what he's doing?
Go back and talk to the review, clarity on why they made that comment initially, and then came to the overall opinion that it was an appropriate report. If y'all would prefer that, do we have time to do?
Report real quick.
It also stated that they were nominal adjustments too. It may not have been that many adjustments.
I guess my concern on the whole thing is if the guy's had his license since 1991, why is he not doing what's correct? Or the lady, whichever, this individual.
Okay, so So I will say that the individual that did the review, we've solicited several reviews from them before, and it states sales for sales comparison adjustments are not properly supported. It was noted that there were some nominal adjustments made. The reasoning for these adjustments were not adequately explained. Although there were no comments found on how the adjustments were derived, overall there is a sufficient information to enable the clients and intended users to understand the rationale for the opinions and conclusions provided in the sales comparison approach to value. And then it goes on to say that the overall report was conveyed in an appropriate manner, and that the appraiser understands the appraisal process.
Alrighty. I guess I have a question that you tell me if it's permissible or not. Somebody in our office has the copy of that appraisal, correct?
The appraisal by the respondent?
Yes.
Yes, we
Okay.
have a copy of it.
Would we have a copy of it. Would it be possible for one of our commissioners to look at that, bring this back to us, and recuse themselves from voting the next time?
You could.
I think that'd make all of us feel a little better, because this individual has not been disciplined since since he got his license in 1991. But there's something doesn't smell right. I'd like to make a motion that Mr. Atwood review this appraisal, bring it back to us at the next meeting, and we'll take it up at that time. I guess I'm looking for a second.
Seconded.
Motion been made and second. Go ahead, and anybody open for discussion.
Are you okay with that? Are you okay with that, Mr. Atwood?
That's right.
Can I ask, is it in the Middle Tennessee area?
The subject property is in Montgomery County.
Get the whole work file.
You have to tell me, are we entitled to the entire work file?
You are entitled to the work file. Yes.
You're hesitant, though.
I'm just thinking about like the timing of the complaints. So I'm just thinking about for like our own. When was this complaint open? If that is what you would like to do, you certainly can do it. Do that and present it before.
Or the other option is to do the letter with the recommendation.
It's up. I guess it's up to you to decide whether that's going to change your opinion or not. If you still, it's either we want to make them do the course or we suggest that they do the course. But I do think that if this person has not been disciplined before, something that you may want to look at as potential, like whether you want them to do the conditional dismissal and have it counted towards continuing education, or send them a letter saying this might be a course you want to take this renewal cycle.
Okay. I'll withdraw my motion. Doc, will you withdraw your second?
Yes.
Okay. Okay. We'll withdraw both of those. Now, further discussion.
I think that since they have been licensed since 91 with no disciplinary action, I think that we should relook at the conditional dismissal and take the reviewer at their word.
I think that's what we set it up for to begin with, no disciplinary issues. We give them some guidance, and if an issue comes up, we have record that we did a conditional ruling before, that's when we take it the next step up.
But this would be in this person's file.
Right, so it's
Yes.
not going to show up publicly on our disciplinary action report or on the National Registry, but it's going to be in their file, so if another complaint were filed against them, you would know about the conditional dismissal prior to it.
Commissioner Mansfield, do you want to make that a motion?
Yes, I will make that motion.
Okay.
I second.
Motion been made and seconded to send a conditional letter of discipline.
How many hours and what course?
Sales comparison, 7 hours sales comparison.
7?
Yeah.
Okay.
At least that.
Yeah, but it will count toward their continuing education.
Yeah.
That's correct.
Okay, all right, motion been made and seconded. Any further discussion? All those in favor of the motion say aye.
Aye.
Any opposed? Thank you. Motion carries. Number 3.
Right, number 3 is 2019-09-2491. This complaint was opened administratively. The respondent willfully attempted to falsify a 7-hour USPAP course completion certificate submitted with 2019 appraiser renewal by writing 2018 to 2019 USPAP on the USPAP certificate. This same certificate was submitted with the respondent's 2017 renewal without the 2018-2019 USPAP written on the certificate. The department indicated, well, the respondent states that the department indicated that their 7-hour USPAP submission was not completed during the required current 2-year cycle. Respondent asked if they could send in the USPAP class verification they were taking on December 6th and submit those hours to meet the requirement. I spoke to Mr. Best about this one, and from what I could tell, it seemed as if the respondent was trying to fulfill the obligations without actually fulfilling those requirements, and just kind of sticking the certificate in with several other certificates with just the handwritten information without actually having completed the requirements. So as a result, this complaint was opened administratively. And I just wanted to discuss this one because I wasn't really sure what to recommend on it, as it seems like it's kind of a bad situation to be falsifying things.
Okay, well, we're going to open the floor for discussion because that's what legal has asked us to do.
I guess a question I have, did they change the document to say a different date, or were they, because I've gotten a lot of calls here in the past couple months, and we, every year or every cycle, we get calls and questions about when a USPAP class applies to their cycle. And this has been going on for years, mainly because there are individuals out there that were licensed in 1991, and the first USPAP didn't go into effect until 1992. And so the cycle is sort of off kilter from when they're taking their classes. And I probably talked to at least a half a dozen individuals that have taken the 2018-2019 USPAP, and they thought that it was counting for their newer cycle, and it's applying to last cycle, and there's just a lot of confusion. And so much so that I even had a conversation with Jim Park at the ASC as far as what are other states doing, and it would require a change of law, but we have 21 hours of continuing ed and then a check for the most current USPAP for that cycle where you're still getting your 28 hours. That's what I think would cover it, because I had someone here recently say that they were told that they had to take the last cycle for it to renew, and that it didn't make a whole lot of sense. So I guess with this one, did this individual think that it was going to apply to that current cycle, or did they need to take the 2021? I guess that's where I was sort of confused on this. You know, if they actually changed a document and changed the date and tried to mislead, then that's a whole nother issue. But was there just confusion as far as when it was to apply?
If they were confused, why'd they write the date on there?
Well, that's, you know, I mean, I'd like to get clarification before we go down the path of fraud or anything like that.
So in this particular case, the certificate was the exact same certificate which was submitted with the 2017 renewal, the exact same certificate. The difference was when it was submitted in 2017. So, 2018.
Says the appraiser willfully attempted to falsify this certificate.
Any conversation with this person?
Just their response to the complaint, and it basically just states that they were told that they could use their certification from December in order to fulfill their obligations, and that they thought they were okay. But after talking to Mr. Best, it doesn't appear that that was the conversation that they had.
They stated from December of 2018, or was this December of 2017 or 2016? Like, what date was the original USPAP certificate for?
So the original USPAP certificate, to my understanding, was the course was actually taken in 2017 during the previous renewal cycle, and he submitted that with his renewal, which he completed in 2017. So when we received the renewal, exact same certificate. It was the same course.
The reality is he submitted a renewal, but he had not taken the current, at that time, the current USPAP course.
Correct. He had not taken a USPAP course during the renewal cycle. I contacted him to tell him we could not accept the certificate because we did not have a course completed during the renewal cycle. That's when he stated that he was going to be taking a USPAP course in December of 2019. And so I told, yeah, so I told him as soon as he took one, then we could complete it, because he was still, his license was not expired yet. He was still within the
Sure.
current cycle.
And you haven't heard from him since? You haven't gotten a new updated version of the USPAP certificate?
No, we did.
Okay.
So I received a new USPAP certificate, which he completed in December of 2019, and so his renewal's been completed.
Okay.
Based on him completing a USPAP course during the renewal cycle.
So he was submitting the same certificate for two separate cycles?
Yes, ma'am.
Okay.
Did he change the date that he took it? Or that date was still in 2017, correct?
The date that he took it had not been changed. What was changed was that it had handwritten on it 2018 to 2019 on top of the certificate.
Did he express any thought that maybe he was waiting on the new course to come out? Did that come up at all, or?
He did not explain. As soon as I contacted him to tell him we did not have a current USPAP completed during the course, that's when he said that he was going to take a course in December of 2019, because I believe this was October or November of 2019 when I was speaking with him. So he said he would be able to send that to me. So,
You have, you have renewed his license. He's in good standing right now.
that's correct. We did renew his license because only legal can do things to their license. I don't do that. I just renew the license. So
He's in this boat, or he or she, in 1991, and that was that window where a lot of older appraisers got licensed right before 1992. And there is confusion, I mean, even this far out from that, when they can take and when and where it hits. And it's recent. I took the most current USPAP Friday, this past Friday, and I had someone come up and they were confused, and they were jumping in and taking this 2021 because they renew in February.
Isn't the issue, though, the fact that he falsified the document?
Well,
Did he falsify the document? He really did. I mean, that was reflective of the 2018-2019 USPAP, correct? That is what the certificate was for.
So that
Or
is,
was it for the 2016-2017 USPAP, and he changed it to 2018-2019 USPAP?
the 2018 to 2019 course, but the course title is already on the certificate. So he had written the 2018 to
Okay,
so because the course certificates have a course number and course completion date, which
Right.
In our licensing system, exactly what the course.
okay.
In addition to the course title, which was on the certificate, he hand wrote 2018 to 2019 on
I
the.
wasn't trying to tell you he had taken a different class.
It was the same class.
Okay.
Because as Mr. Garrison stated, because the requirement is not to take a specific year for the USPAP, it's to
Right.
take any Tennessee approved
Within your 2-year
USPAP
cycle.
during the
Yeah,
2-year
yeah.
cycle.
And
Not a
that's where
specific
if we could get that changed, a lot of states are requiring you to take the most current USPAP within the first 6 months of it being issued. If we could get that changed somehow to where it's a check mark and possibly clear that up, I think that would help us all and help appraisers across the state. But that's going to require, and it's not going to happen quickly.
So he wasn't confused when he renewed his license in 2017.
He was not.
Right. Do we have a copy of this that we can look at? Huh? You want me to make a decision on something that I can't look at? Oh, we don't have one. We don't have a copy of the one that has the handwritten.
I don't.
I'm gonna check. I'm looking, but I don't think we do.
Is the question whether or not he actually did handwrite it on there?
I would like to look at it and examine the whole document.
Because there could be some intent there that's like, oh, I got their certificate and I wrote on there, okay, remind yourself this is for the 2018-2019 USPAP class.
Or they also may have thought, since they were renewing within that time, that this would, suffice that, so.
This actually makes no sense. Why someone with a license since 1991 would even attempt such a thing willfully. It makes no sense.
No record of any other disciplinary actions.
I just write what's in the complaint. It's not my choice of words,
We're
but
not
that's
saying-
what's in the
and-
complaint, and that's how it came off to the person who filed the complaint. So that's why I wanted to discuss it, because it was a bit confusing to me myself. And I did talk with Will or Mr. Best, and that helped a little bit, but I don't know the whole process of what you guys have to go through in terms of submitting those documents. So it was helpful for me to hear this whole discussion. And because this respondent is licensed and certified and up to standards, I would recommend we dismiss this one. But I do want to hear from you guys and get a vote on what you all think also.
To Rex's point, whatever the process is to get this changed, I think we need to start down that path because, we need everyone taking the updates within 6 months.
I think also at the very minimum, if there is some confusion there, a letter of instruction kind of outlining the process that they do have to take the most current USPAP version within.
The motion.
That's good.
I'll put that in a motion.
I'll second it.
A motion been made and seconded to have a letter of instruction informing this individual as to the deadlines and to the process of the correct USPAP in the correct renewal cycle period. Any further discussion?
I'm sort of, leaning in that direction because apparently there's been no other disciplinary actions. And that kind of leads me to favor being more lenient in this than if we were looking at someone who had a lot of issues over his or her history.
All righty. Any further discussion? Ready to vote? All those in favor of the letter of instruction say aye.
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 Any opposed? Motion carries. Now we're going to move to number 4, but first we're going to take a 10-minute break.
Mute.
Legal number 4. Does that sound right? Okay.
That's right. Number 4 is 2019-096941. This respondent basically just reported all of the discipline that he has had as required. So this respondent was disciplined in 2 different jurisdictions. In one jurisdiction, they were disciplined for unlicensed activity. They had a permit to conduct appraisals for a limited amount of time for one specific project and continued. It didn't specify how many other projects. It just said the license expired and the person continued to do appraisals. And in the other jurisdiction, there were just various USPAP violations. Sorry about that typo, but I meant USPAP violations that are just, it was a lot of them, but I won't bore you with all the details unless you just want every single one, but those are basically the reasons why this person was disciplined, and they just reported it to get a head start.
I just have a quick question for you. Under their license and disciplinary history.
Right.
Recommendation. Motion been made. Do I hear a second?
Second, for discussion purposes.
Motion been made and seconded for discussion purposes. Okay, we'll open the floor.
I'm not 100%.
I'm not either.
Me neither.
What is the actual complaint?
So, individuals are required to report their discipline whenever they renew their license. And this is what happened with this individual. And so when a complaint is brought to me, I look at a complaint to see whether or not the commission has jurisdiction or not. We do have jurisdiction over this complaint because it is one of our appraisers, but doesn't particularly pertain to Tennessee. We don't really have reciprocal discipline, where sometimes if another state has disciplined an individual, you can be disciplined here. So that it was just, the complaint was opened because the individual self-reported. So that's basically the extent of it. There's not, if it was something egregious, like if someone's license had been revoked from another jurisdiction, then you can make a decision whether you would like to revoke their Tennessee license as well. So that's basically what we have before us. But this would just be kind of like any of our other individuals that have prior discipline applying or renewing their license in another jurisdiction.
I will note also that for one of the jurisdictions, this person's license was suspended and they were placed on probation because there were so many USPAP violations. Just to put that out there.
So that would have had to been California because they weren't licensed in Arkansas. And what are we doing with this?
They have a Tennessee license.
But they don't have any violations here.
No.
They're just disclosing?
It's
required?
disclosure.
Okay. I don't say that we have to take any action.
You don't have to take action unless you want to.
What am I missing here? This guy's, we're opening a complaint because this individual was honest?
So
this person submitted the complaint on the respondent, this appraiser. They submitted this complaint.
So individual,
yes,
self-reporting to let us know that they've had prior discipline. So if someone is disciplined in another jurisdiction, you're required to let us know when you are renewing your license. So they are being proactive in telling us. For example, if someone had not let us know that they were disciplined in another instance, we'd be having a completely different conversation.
And they,
Do you check every application with the ASC or somebody to see if they have prior complaints in other states? You check every application?
I'll turn over things side.
Every initial application is checked on the ASC. Also, all temporary applications are checked on the ASC.
But renewals are not?
No. There are, on the renewals, there are the questions that they must answer if they've been disciplined in any jurisdiction, also whether they've had any convictions, et cetera, and jurisdiction, professional license.
But they actually opened a complaint on themselves? Okay, so, but the application is different. You just have to answer a question. You don't have to file a complaint against yourself.
As far as I know, I don't think it's, Anna, I don't think you have to open a complaint. It's just something this person did.
well, they've had disciplinary issues in in 2 states in one cycle.
Let me see the date on.
Because either they reported that they renew May 2020, so they last renewed in May of 2018.
One of these for a violation in 2016, but the order wasn't. Other one also had violation. Does that make sense?
I have a question on that. On the renewal form, does it say that there's been any discipline or that there's been... I'm trying to think of the way ours is worded a little bit differently. If you have any open investigations.
Can you repeat?
Yeah, on the renewal form, does it say that have you had any discipline or have you had any open investigations? I think the AMC form, and I may be getting it confused because we have so many of them, but it asks if we're under investigation in any state.
I don't know about renewal forms.
Okay.
I don't think it says, under investigation, it's not listed on there. It's convicted, suspended.
It's subject to any discipline. What it says.
This individual submitted the separate process, not in conjunction, contacted and filed a complaint.
So just I guess if you wanted to know more why the complaint was opened, 6239-326 is the statute that talks about revocation or suspension. And so one of the grounds for discipline includes a violation of any of the standards for appraisal and appraisal practice. So, for example, as we saw in the other state, they decided since the individual had USPAP violations that they wanted to take action because of that. So I just want you to know, if you were to make that decision, there is those would be the grounds for it. So that's why most likely the individual self-reported there too. So it's just, the reason it was open was because they let us know about it beforehand. It's totally within your discretion what you would like to do.
We know if any disciplinary actions were taken and what they were, if there were.
One jurisdiction suspended this person, and the other assessed a civil penalty.
Do we know the details other than that?
One jurisdiction is unlicensed activity. The other is just a slew of USPAP violations.
Right. I was wondering, though, what discipline they were subjected to. Did they have to, were they fined? Were they given a course?
One jurisdiction assessed the civil penalty, and the other one suspended this person and put them on probation after the expiration of the suspension.
How long was the suspension?
Let's see. Suspension was, and then the probation was 18 months.
Seems to me, I mean, I can't see that we take any other action here except to know that we're on call, that this person has had some history, and, you know, if something should come up, then we could take action there, but I can't see there's anything we need to do.
I recommend that we dismiss it, and we have in the record what has occurred, and if something does come up, we at least know this much, and we can take action then.
Do we communicate with this applicant at all to say that, well, thank you, and we will be, you know, on guard with this?
So they'll just receive a regular if this was dismissed, or a regular closure letter saying that the complaint has been dismissed. But if you would like, we could reach out to the individual and send them a copy of the meeting so they could see at least, you know, the discussion that we took place here. So.
Yes, I move that we follow the information that we've just been given, that we go ahead and, you know, not do anything in terms of a punitive action, but that we communicate with this individual and let them know that we're aware of the record. In fact, they've made us aware of it, and use the information that counsel has advised.
All right. Here a second.
Second.
Motion been made. Follow up with it. All those in favor of dismissal for number 4, vote yes.
Yes.
Any opposed? Motion carries. Number 5.
Sorry, the last one is a represent for an appraiser that was, for a respondent who was assessed a civil penalty for unlicensed activity. This respondent basically, it was found by the expert reviewer that the appraisal report constituted a fair value report association. Then the reviewer concluded that the report is a disservice to USPAP, and as well as an appraisal report of real property as defined by market value. Although the report is disguised to represent a market value appraisal report with respect to its construction and including definitions and clarity is That's just kind of a little background on what this complaint initially was about. This respondent has an attorney who wanted me to represent this to you all with this new information after our meeting in October of 2019. The respondent states that they now require all appraisal professionals who provide significant assistance to an engagement sign the certification of each appraisal report. And also, this respondent is requesting that instead of being assessed the civil penalty, that they be required to complete a 7-hour USPAP course for non-residential real property and a 4-hour that's a violation course.
And as legal counsel, where it says
That was the prior recommendation. The new,
was to dismiss.
the, so the
$1,000.
prior recommendation was dismissal, and then the decision that you all made was $1,000 civil penalty per property.
Right.
So a consent order was sent out for an $11,000 civil penalty.
Right. As of this represented, does council have suggestion to us?
So basically what their counsel has, I guess, counter offered our settlement offer of $11,000 with the new information that's been presented here today. It's up to the commission whether you would like to accept this or to move forward with a formal hearing on the matter. I'm not going to influence your decision. We're not going to influence your decision. It just depends on what level of comfort you have with their settlement offer, if you believe that it is fair way to handle this matter and close it.
All right. Thank you. Let's open this for discussion.
When was this first presented?
I believe it was originally presented in July. I know that I presented it to you, and we recommended it for dismissal, and then there was extensive discussion that we had during the conversation, and one of them was I think there was we read a certification that was included at the end of the document. We had not seen a document like this before. It looked like it was a mass appraisal, or I don't even want to say appraisal because a mass of, I guess, can we say it? Cell phone towers that they were looking at. And so we didn't believe that necessarily this fell as a use PAP violation, but the commission ultimately decided that it did. I think in this matter, if you were to like to know my opinion about it, is that $11,000 civil penalty is a significant amount of money that we're requesting from an individual. But if the decision or the will of the commission is to address the issues and the conduct that was that took place, that the settlement offer may be something that we can for sure make sure that the individual completes.
I'm going to show my ignorance even more than usual here. There's a mention of a $1,000 penalty. What's the 11,000? What's the other 10,000?
It says $1,000 per property that had been appraised.
Okay. I'm sorry.
So we went back and looked,
So there were 11
and we
properties.
found 11 properties.
Okay, thank you.
I have a question in the new information.
Expert reviewer found that it was a fair value report, but apparently the appraiser who did it considers it an appraisal report because now he's going to have people who provide significant assistance to an engagement sign the certification for each appraisal report.
So they don't admit to that they're not admitting to the fact that it's an appraisal. That statement was made just for the purposes of covering themselves with the commission, but they state explicitly in the letter they sent me that they do not agree that it's an appraisal, but they're just doing this to alleviate any future issues regarding any of these type of valuations that they do. But they do not agree that it's an appraisal, which is something I'm sure that they would argue if we move forward with the hearing.
What I remember from this case, they came in, they were unlicensed, apparently we didn't have that number of properties that they valued, but 11 properties in the state of Tennessee did not obtain a license to do so. However, they had an individual on staff that got a temporary license. The temporary license is for one property unless they specify how many properties they are doing. That wasn't the case. So at the end of the day, it was a unlicensed appraiser, valuer, or whatever they want to call it, come in, and they do fall under what we do. And as far as the reviewer states that it was evaluation. I think we had the certification read in July, and it sounded like they were making an attempt to meet USPAP, and that's a concern that they're coming in valuing without getting a license, and that they're recommending only a 7-hour class, and that's a big difference. So I personally disagree with their proposal. This is an issue, coming in and valuing without obtaining a license. Has anyone from this company gotten a license since then? And apparently they had one that got and I thought we opened up an administrative complaint against the person that got a temporary license. Okay.
So it looks like the individual that had the temporary permit at the time is now licensed with us. Their license expires in this year, next month. It looks like at the time, I can't remember. So at the time of the appraisal report in question, they had a temporary permit, but since then the person is now licensed with us as a certified general appraiser.
So they are, by doing that, they're admitting that they should have been licensed.
So they were licensed. The temporary permit person was licensed in 2018. So after this was done, they were fully licensed with us, but before the complaint was filed. So the complaint was opened against the individual that had their name at the very bottom. They're not licensed with us, but there was a series of individuals from various states that were listed, and the person that had the temporary permit with the state of Tennessee is now licensed as a certified general appraiser. But at the time, they just had a temporary permit.
Let me ask you a question.
Yes.
Is a temporary permit for all 11 properties or for one property?
A temporary permit is supposed to be per property.
That's kind of what I thought. So they expanded it, or are they considering all these 11 properties to be the same property because the same individual and or corporation or whatever owns them or hired them?
Based on the report, it looks like it's 11 separate properties,
But one permit.
but one permit, so that would be an issue, but that is not who the complaint that we're looking at has been filed against. So I don't believe that we administratively opened a complaint against this person, but as something that we could do against the individual that had the temporary practice permit. But the person here, the respondent in this one, is not licensed.
It's not licensed. Yeah.
My question is, if we go back to that, they had a temporary practice permit, so they had the understanding that they needed to get a temporary practice permit to, based on the argument, is not to complete an appraisal. They wouldn't have had to get a temporary practice permit if they didn't think they were completing an appraisal.
Also, too, I mean, our laws and regulations are online. I mean, that information is public knowledge and is out there. I don't think that we want to set the precedent that it's easier to beg for forgiveness than ask for permission.
No, and we definitely need to go back and open up a complaint against the temporary licensee because they got unlicensed activity.
I thought that was recommended in July, that we do an administrative complaint against that individual, and to.
We'll fix it nonetheless.
Okay, yeah, but this one, I think we need to stick where we are.
With the $11,000 fine.
So, Anna, am I correct in saying that we stay where we are and we hold our ground at $11,000, then this will come to an administrative hearing?
More than likely, it will. Yes.
Okay. Any further discussion? We have a.
Do we have to have a motion for this?
Let's have one just
Yeah.
in case.
Entertain a motion.
I move we leave the penalty the way we approved at the prior meeting.
I'll second that.
And the administrative complaint.
We'll do a separate motion on that.
Okay.
Motion been made and seconded to leave our decision from July meeting the same. Any further discussion? Everybody knows what you're voting on. All those in favor say aye.
Aye.
Any opposed? Motion carries unanimously. Now,
I make a motion that we open up an administrative complaint against the individual who held a temporary license at the time these reports were completed.
Second.
motion been made and seconded to open up a complaint against the individual who has the temporary license. Any discussion? I have just a quick question, Anna. Do we open 10 complaints because it's 10 individual properties, or just can we do it under one?
You can do under one.
Okay, that's all I need to know. All right. Any further discussion? All those in favor of the new motion say aye.
Aye.
Any opposed? Motion carries. Does that complete legal?
No, there's one more.
Oh, yeah.
The addendum presented before you. So that's 2018-09-1301. So this is a complaint that was originally, I'll just skip down to the new information. So this matter was sent to the respondent for a conditional dismissal and signed by Council and respondent on September 4th, 2019. Council recommended respondent complete a highest and best use 15-hour course and a sales comparison approach course for 30 hours. After multiple extensions, respondent has failed to complete any of the recommended educational courses. To date, respondent has not submitted any of the required education. Therefore, council recommends that respondent be assessed a $1,000 civil penalty for the above-mentioned infractions of USPAP. The USPAP violations can be found on the page beforehand. So we have at least 5, I believe, USPAP violations that the expert reviewer found. The respondent just has not been cooperative, and they have not completed any of their discipline to date after they signed it.
Question?
Yes.
Is your recommendation in lieu of or in addition to the previous?
That is just, it can be both. Okay. I think that sounds good if you would like them to take the courses and have a $1,000 civil penalty. I'm not committed to it either way.
I have one question. It was a conditional
Dismissal, yes.
dismissal. So would they not submit that information or the proof of taking those classes until their renewal? And it looks like they renew April of this year.
No, so in the terms of the conditional dismissal, when you sign it, we provide an amount of time that you have to complete it. And so they had 90 days, and we gave them further extension after that, and they still have not completed it.
So they take it and then it applies to
Correct.
the renewal.
Yes.
But they haven't done anything.
They haven't done anything.
They were given grace and.
Yes. And even informed that if you had this extension, if not, I will present it before the commission, so they were well aware of their options.
All right, do we have a recommendation on this?
I would move that we remove the conditional dismissal. And we require all of the courses that have already been required, plus the $1,000 civil penalty per violation.
Second.
Motion's been made and second. Open the floor for discussion. I just have a question. Jim, do you want to add a timeline to that?
These courses cannot, did you have 90 days? Really, I mean, being honest, I don't think you can take these in 90 days. They're not offered. And so I would have to at least say a 6-month time period.
Okay.
And I didn't realize under the
180 days.
conditional that there was a time frame. I thought it was to be suggested during their next renewal cycle to take the classes.
So we put a time condition so we are able to make sure that they've completed it. Otherwise, we wouldn't know whether they've done it before their cycle beforehand. But if we are that helps to know that we need to extend more time. Typically, if someone does ask for more time, we give them more time. So it's not that extensions are denied. But if they're not offered as often, is it possible, do you think someone would be able to do this in 120 days instead?
They're getting ready to renew in April.
Of 90,
April
I'm just
22nd.
talking about like in general for the future when we set time parameters for courses. If 90 days is extended to 120, does that help?
I would give 6 months.
180 days?
Mm-hmm.
Okay.
Wondering too, in some instances, people can't take these courses because they're not offered at a location that is convenient. Now, I know we have a limitation on the number of hours that can be taken by distance learning, but I would think, and I don't know what the mechanism would be for allowing this, is to let that person take courses that are required because of a punitive action by distance learning, if they're available, as opposed to classroom learning.
So, what I'm sorry, I have lost what I was going to say beforehand. Usually what happens is if someone has planned to take a course, they reach out to us and they let us know. And if they need more time, we give them more time. That's not the case that has happened with this individual. We reached out to them after the deadline. They told us that they hadn't taken the courses, hadn't made any arrangements to take the courses. And it's interesting that you bring up allowing it to go above and beyond. We told them, even though as the rules state right now, you can't take these online, I offered them to take them online with the acknowledgement that it would not count towards their continuing education. And that was also, I was turned down by that as well. So,
By whom?
By the respondent. I offered that to them as part of their extension to let them know that they could take it online, but it just wouldn't count towards their CE. But they said no. So,
But, wait a minute, they're able to deny a punitive action that's taken?
well, they're
I don't
not
want to do
able
that?
to deny it, but I did offer it in as part of my extension. It was either you can take these online and they will count towards they won't count towards your CE, and you have until this date, or I represent it before the commission. And so that's the route that we
Only
went.
something they should be able to negotiate about. I'm sorry.
And at the current time, this 15 hours and this 30 hours are not going to be applicable to their renewals?
They will not, as it will be in a consent order.
Okay.
I have two questions.
Yes.
Can they renew without doing this? Will there be a blockage on their renewal if they don't do this? And my second question is, what's the time limit on the $1,000 civil penalty?
So whenever we send out a consent order, the individual has 30 days to accept the consent order or reject the consent order. We require civil penalties to be paid within the amount of time. However, some individuals, we will create payment plans to allow them to pay it if that is required, if they need a civil penalty. Did that answer your question?
And they renew with this still pending?
Yes, they can still renew their license.
Okay.
There's nothing we can do to stop them from renewing their license because it is not like a final order or anything of the sort. But I don't anticipate this individual to settle this matter, so it is likely that this matter is going to be presented to you in the form of a formal hearing.
I have a question. Their licenses are, if I read this right, are renewable or need to be renewed on April the 22nd. Are we saying with this hanging over their head, they're in good standing?
Well, because we don't have formal discipline that has been instituted against them because we don't.
Because they haven't signed it.
Right. So they've signed the conditional dismissal. And if you remember, the conditional dismissal does not count towards discipline. Okay. So anything else, they would have to sign a consent order. So they have already violated the terms of their conditional dismissal, but as it stands, that is not considered formal discipline, which is why we have to bring it back before you. I'll say I think this is the first time we've had someone not complete a conditional dismissal, so usually individuals are more receptive towards it.
When was this first submitted to us?
So
because and I may be confusing it with another one.
It was never presented before you because it was a conditional dismissal.
Okay, so we never.
No.
Okay.
You have not seen it.
Okay.
Any further discussion or recommendations?
Can we suspend license until?
I was thinking.
That would have to be. They would have to agree to a suspension as well.
All right?
How did we not have this come in front of us? I don't understand that.
So if if someone has not received discipline before, we do a conditional dismissal. And so the conditional dismissal is sent out to the individual with the violations and the recommended education. And it's not part of the legal report.
Okay, I feel like we see a lot of stuff that didn't have previous discipline before.
So,
And
like,
there's
for
a
example,
lot of violations
like
in here.
for today, the one was brought to you because we recommend it for dismissal. We recommend it for dismissal, and so we can't unilaterally dismiss something without your recommendation. But no parameters were set with the conditional dismissal. With if you have this many violations, then it goes straight to the board. It was just if they have not received discipline before, and if the expert reviewer finds issues, then a conditional dismissal is brought before is the route. So we didn't have something like if you exceed 5 USPAP violations, it goes directly to the board for formal discipline. It's just sent out for a conditional dismissal.
Okay, so today we have a 15-hour course and a highest and best use course, plus a $1,000 fine that the individual has not signed?
So, like, no, they have not signed. So
Has this been sent to them, though, to sign?
this hasn't. This
Okay.
is being presented to you as a.
Okay. Okay, that's all I
For
need to
them
know.
to sign.
That's all I need to know. Okay. You all see in front of you a 15-hour highest and best use course and a 30-hour sales comparison course and a $1,000 fine. Is there any further discussion on this?
Just wonder, I mean, if we ask them to do this, I'm not going to do it, or they don't do it, what's the next step?
A formal hearing that would, depending on whether they're represented or not, the soonest it could be brought to you is at the next commission meeting.
All right, Chair will entertain motions from the
I've already
commission.
made one.
Oh, I'm sorry. And it is?
I don't know if I got a second or not. My motion was to remove the conditional dismissal aspect, to continue to require the courses that were required, and to add the additional $1,000 civil penalty per USPAP violation.
I'll second that.
Okay, a motion been made and second.
And we've got 5 USPAP violations in here. Correct?
Or I think at least 5. I'll go back and look, and I'll do it recording.
Was this $1,000 per violation?
Yes,
Okay.
I'll make sure that it's
Okay, so the
$1,000
motion
per
on the floor
violation.
is to dismiss the conditional dismissal, require highest and best use, 15 hours, sales comparison, 30 hours, and a $1,000 fine per USPAP violation, however many that is.
Second.
Motion been made and second already.
I'll withdraw mine. I wasn't under the impression it was per violation. I thought it was 1,000.
Okay.
So,
Okay, so we have a motion and a second on the floor, and it is $1,000 per violation. All right, any further discussion? Ready to vote? All those in favor say aye.
Aye. Aye.
Any opposed? All right, motion carries on number 6.
I have one more thing. This is not the legal report. We're done with the legal report, but it's for rules. So if you guys will go to your iPads, you'll see a set of proposed rules on your iPads. I think it is number 8. So you'll see the red line. I want to give some background over what happened very briefly. So these rules were approved by the commission on July 15th, 2019. These rules were in response to the audit findings that we had from the appraisal subcommittee. The rules went all the way up to the chain up to the Attorney General's office for signature. However, during that phase, the Attorney General's office determined that a provision of the rules that we were not changing, they had a problem with. They believe that if you'll look in the red line number 6, if you'll go down to In the beginning on the fourth line, the section that is in red and marked out, and it says and/or imposition of civil penalties up to $1,000 per violation or otherwise disciplinary action in accordance with the applicable law and rule pursuant to 10 code annotated. That's supposed to say 6239-326. The Attorney General's office believed that failure to take the 7-hour USPAP course only constitutes grounds for revocation, suspension, or restriction, but not the imposition of civil penalties based upon our own statutes, and therefore they recommended that we take this portion of the rule out. And so this is considered a substantive change and not something that is and has to be approved by you. So all of the other changes are the same. It's just that we also have to remove this one portion because they don't believe that the statute supports this.
So this is for informational purposes. We don't need to vote on it.
No, you still have to vote because it is different from the set of rules that I brought to you in July.
All right.
And it'll have to be a roll call vote.
Sure. All right.
I've got a question before
Sure.
we get. If this is on the table, and this is what we talked about earlier, is there any way to, the most current USPAP version of USPAP, while we're negotiating that, or is this, take it as it is?
So for...
Because that was what we brought up earlier, was that there's a misconception about when and what version of USPAP they have to take within the renewal cycle. And, it looks like this is discussing that. Can we add to this, or no?
It was... Okay, how about we do, I want to make sure that the rule doesn't conflict with the statute, because if there's a statute that says otherwise, no, we can't do it, but if it's only in rule, then that can be something that we can change. So I haven't looked at the statutes yet, so if you'll give me a moment to look at the statutes to double check, that could be something that we could do. But I'm not sure at the moment. I think we're okay, but I don't want to say it until I know. So, if you guys want to come back to this, we can do that.
All right, we'll come back to this.
We'll take a look at it.
All right. Jennifer, are you ready for the budget? Okay, go ahead.
You'll see this goes through November 2019. Largely in keeping with previous months and fiscal years. You will notice in October on the other section, that includes the new AMC dues. So that's the reason for the spike there. Other than that, if you have any questions, I'm happy to do my best to entertain them.
Any questions for the director? Does the budget require us to vote on it?
No.
Okay.
It doesn't require action.
Okay.
And it says complaint reports, but there are no current complaint reports.
About new business. We have any old business? Any new business?
So new business, we had some questions about continuing education and at what point, which cycle for which they count. I'm going to let Mr. Best speak to this. He's my expert in this area, so I'm going to let him speak to this. I think there's been a couple of questions.
So the question came up about their continuing education taken at the end of one renewal cycle could be counted towards the next renewal cycle. The answer is no, and that's based on the federal requirements from the Appraisal Foundation that continuing education taken in excess of the required 28 hours will not carry over to the next renewal cycle. That's specifically prohibited by the Appraisal Foundation. It's not specifically in the Tennessee rules. In Tennessee rules, Tennessee appraisers have to follow the federal standards set by the Appraisal Foundation. The Appraisal Foundation actually has a frequently asked questions section, and that specific question is a question whether the carryover can occur or not, and it specifically says no. So we're not permitted to carry over continuing education cycle. And this is somewhat related to Mr. Garrison's point about the use PAP and whether we can have one in the next cycle and things like that. And I think part of the problem with the rules, the way they're written, the federal and state rules, is there's no specific use PAP required, no specific year required for a renewal, only that they take a use PAP update. And so for any particular appraiser who renews their license, they could potentially have one of 3 different use PAP updates depending on which day of the renewals, which day of the licensing period they took a use PAP. And so most people don't realize that that's the way the rules are written, but because the rules don't specify a specific year, they can take any Tennessee approved use PAP course.
Based on, we ran into this before, just for clarification before we go down this, our rules can't be any more strict than federal rules, correct?
Correct.
USPAP is not a rulemaking body. It provides minimum standards for appraisers that all have to be approved by each state entity. So USPAP does not make the rules. They suggest rules, and then the state approves. But you're telling me that the minimum rules that the Appraisal Standards Board has come up with and the Appraisal Qualifications Board, we are stuck with them. We can't. In fact, I don't think that's even true because we've already changed. In the past, we already changed the, for example, the supervisor trainee course was required by the foundation to be 4 hours, and in the past, this body made that a 7-hour. Now we've changed it back to 4, but we have precedent where we have changed those rules or those suggestions or whatever. USPAP has no authority to make us do anything. The state decides whether they're going to or not. And so at this point, you would have to tell us the state has made that decision.
Okay, so statute 62-39-329 states, it is the intent of this chapter that real estate appraisals be performed in accordance with generally accepted appraisal standards. Therefore, state licensed and or certified real estate appraisers must comply with the uniform standards of professional appraisal practice promulgated by the Appraisal Standards Board of the Appraisal Foundation and any other duly established standards of the Commission.
Yeah, as minimum standards. We can do more than minimum.
The Commission shall not establish any criteria for licensure that are more stringent than the criteria established by the Federal Appraiser Qualification Board.
Are there not some other states that require or specify that you take it within the first 6 months you take the most current?
Yeah.
So,
Yes. There's a number of states that say you have to take the current course.
Right.
And North Carolina, I think Georgia. There's several adjoining, Kentucky does, several adjoining states to Tennessee.
So how do they do it?
I think we're talking about the carryover of courses from one renewal cycle to another, not the 6
Yeah,
months.
but that fits in. I'm the one that posed the question, so I'll let the Commission hear why I posed it. I'll just give myself as an example. My license renews on December the 13th. On about December the 7th or 8th of last year, I took a 7-hour course, and then I took the 7-hour USPAP update for 2020. And I got no credit for either one of them because they were 5 days before my renewal date. Therefore, I got to take them over again. That seems to be absolutely absurd. It is what Mr. Garrison is bringing up. It is what might have been the problem with our complaint earlier, that he thought he could take something, and I don't know what's going on with that. But for me to have taken USPAP 5 days before my renewal and not be able to get credit for it sounds absurd. Now, if it's a state law, we have to go by it. But my question is, can we change it?
And that item that I brought up about our laws can't be any more stringent was changed in the last year, because it came up when we were doing the rulemaking hearing that we spent the entire day on, that we tried to change our law for online education, and we got to the end of the day and our rules were more stringent than the federal rules.
No, they weren't. And she addressed that. She addressed that they say we have to take the classes, but they don't address the manner in which they take the classes. So that's two different things.
Okay. I didn't think so at the time.
Well, she answered your question in the last meeting.
Is this law or is it a regulation that can be changed? That's my question.
The law, it's the one I just
It's a
read
law
you.
that requires legislation.
Do other states allow for carryover of continuing education from one cycle to another?
I can't name one, but I would assume there are.
I don't know of any.
It's my understanding.
And really, it's not a matter of carryover in hours. Where it gets into an issue is USPAP.
I think we're having two separate conversations. So the continuing education update was from continuing education, whether it can roll over to the next cycle.
Yeah, if you take
But
35
it just so
hours or-
happens to be that we're talking about a USPAP course. So if we're talking about carryover of one from one cycle to another, the criteria does not allow for that to happen, so we can't change it.
Right.
But we can change, I believe, the matter of how the USPAP course is taken if we wanted to change it to be within 6 months. That's something that we can do. And so I looked at the statutes to review it, and I don't think that it conflicts with it. The only thing that I would like you to consider is, first of all, this is the first that I'm hearing of it today, so I haven't figured out what language to use to put in that rule. The second manner is that the rules that I brought to you today, we need to have these done before the auditors come back in the fall. And so that's what we were trying to do prior to this. So it may be what you're wanting to do can be achieved. I know it's going to sound frustrating in two different packages, because first, we're required to let individuals know when we're making rule changes, so if they want to talk about it, even before the rules are promulgated, so they can have input in it. I don't think we'll have a lot of pushback on changing the USPAP requirements, but we might. And so I think this needs to be two separate packages, mostly because I need to figure out how to word this specifically and figure out also if this is the particular rule that we need to fix, because it may be that the rule it's stated differently in other parts of our rules, and so I want to make sure it's uniform.
So can we vote today on the first one and you bring the second one back to us next time? Does that give you enough time
That gives me enough time to do that. So that's just like my opinion. If you guys are okay with that, like, I don't have an issue with it. I've looked at the statutes. I think that is something that we can certainly do, but I will double check with our policy managers at the ASC and see if that's okay, because I want their approval too before we do anything. And then come back to you in April with the proposed set of rules and language and how that will go.
Okay. So we can take a roll call vote today on the rule change that you presented to us,
Right, but
without
I want-
the term current in there. Is that correct?
So I will formulate rules based upon our conversation and see what we can do. But we were talking about the continuing education rollover requirements first, so I just want to make sure we finish that conversation to see if we have any other questions on it.
Well, you're basically saying continuing education has to occur within the 2-year actual period of time in which the appraiser is licensed, it cannot roll over.
Yes, that's my understanding.
And that rule cannot be changed.
That is not a rule that we have promulgated. That is a criteria that's from the Appraisal Foundation and Appraiser Qualifications Board.
That rule can be changed by the state.
The AQB,
We may not want to, but it can be.
it's not my understanding that we can have standards separate from the AQB.
That would be a state decision. It would not be an AQB decision.
That's something else that we can also think maybe something that we want to talk about in April, but that was not my understanding right now, so that would probably be another
Well,
question.
I'll withdraw the conversation. I mean, I think the main thing is the USPAP deal.
I'll check on it for you.
Okay.
I'll check on that conversation. I just want to make sure that everyone's on the same page because we're not right now, and then I'll come back to you in April with an answer one way or another.
Okay, so let's get everybody's on the same page. We're going to take a roll call vote based upon what council has suggested as the additions and subtractions in red line to the rules. Okay. All those, any further discussion?
Michelle Alexander? Dr. McCara?
Yes.
Jason Bennett?
Yes.
Jim Atwood?
Yes.
Randall Thomas?
Yes.
Rex Garrison?
Yes.
Brett Mansfield?
Yes.
Okay. Now, in April, you're going to bring back some additional information for us to discuss in regards to this
Yes.
under old business.
Yes.
Okay. Anything else that you want to go back to what we discussed a while ago? Are you going to bring that back to us? Okay. Any other business?
Do we need to talk about Arrow?
Yes.
We do. We have the Aero conference. We need to vote on attendance at the April I'm sorry, at the Aero conference because it will take place prior to your April meeting. And just as a note, Mr. Mansfield and Ms. Alexander have not attended yet, and I think it was suggested that perhaps some of the newer members who hadn't gone could be allowed to go.
Give us those dates.
It is April 3rd through the 5th.
All right.
How many are we allowed to have?
I think Mr. Thomas was saying that they will pay for 2 in the past. They've paid for 2, and I can double check. I know there were some members that wanted to go and even pay their own way. But if it's 2, I can check and see if it's going to be 2 or 3
I think they've
this
always
year.
approved 2, and I think maybe one time they approved 3. Does that sound right? But yeah, 2. Is there anybody who knows they can go and wants to go?
I can go.
I would be interested. Are you?
I need to withdraw. I actually can't that weekend, so I'd put mine. I definitely want to go to DC in the fall, and I'd already have that marked down, but I can't to this one. So,
Have an opportunity to have that window open, Michelle. So Mr. Garrison, Mr. Atwood, and myself want to go.
Okay.
All right,
And having
you-
not gone, I think I'm going to try to attend that one
And
as
you
well.
can put these 2 in front of me because I'm going.
Okay.
Okay, I'll pay my
Okay.
own way if I have to. I'm not worried about that.
Okay. And I'm going to check on Ms. Matlock as well.
Okay, all right. Any further business? Awful quiet. Chair will enter.
The follow-up research. Okay, so at the last meeting, you guys had questions concerning the AMC that was revoked the bond question. So the response to that is that if an individual that was aggrieved by the company, they would need to make a claim to the bond company against this the bond that's in place with the commission. So the commission is the obligee in this circumstance. So if the bond company were to make payments dispersed from that, it would go into the commission's operating account, and then our fiscal services individuals would disperse the funds to the individual. So they would first need to make their claim with the bond company, and that information is available if they request it. So I knew that was a conversation that had beforehand.
Because there was. Oh,
We haven't. No one's made a claim for us against it, so we haven't heard any from anyone.
Anyone else? Chair will entertain a motion to adjourn. Second? Got a second? All those in favor, say aye. Leave.